Good morning. Thank you for inviting me to speak to you today. Most of my talk will relate to a fundamental principle. The government should treat everyone equally, regardless of what their religious beliefs are, so that the opportunities the government provides to people should not be affected by whether or not they believe in a divine higher power. One would think that today, in a liberal democracy in the 21st century, these should be widely accepted ideals that are beyond dispute. But it has become harder and harder to uphold these ideals before a federal court system that has become increasingly hostile to the principle that religion and government should be kept far apart. I'm going to tell you about some recent cases that demonstrate how these principles are increasingly under siege. I'll also talk about how, despite the deterioration of the federal courts, my organization is continuing to fight for the separation between religion and government and for religious equality, and how we've adjusted our strategies to be more effective in a difficult legal environment. Hopefully, I'll be able to provide you too with some inspiration about how you can keep fighting effectively for what's ethical and right, even when you have suffered setbacks, and when it appears that powerful forces who pay little regard to ethics and humanity are arrayed against you. I'll start by discussing the lawsuit against officials of the Pennsylvania House of Representatives, in which I represented the Philadelphia Ethical Society and its late Leader Emeritus Richard Kiniry. The Pennsylvania House regularly opens its session days with an invocation. About half of the invocations are delivered by House members, but the other half are delivered by guest chaplains from the community who are invited by House members. In 2014 and 2015, several Pennsylvania atheists and freethinkers contacted the House and asked for permission to open a House session day with a secular invocation. Instead of invoking a divine higher authority, they wanted to invoke secular principles or authorities, such as equality, justice, toleration, or the founders of our nation. The House refused, taking the position that, quote, non-adherents or non-believers would not be permitted to deliver the invocation. The main justification that the House gave for this brazen discrimination was that the House's rules permit only members of religious organizations to serve as guest chaplains, and that, in the House's view, the non-theists who had applied to deliver invocations were not members of religious organizations. So we filed a lawsuit in federal court on behalf of 5 Pennsylvania non-theists and 3 Pennsylvania organizations for non-theists. After we filed the case, we were contacted by one of your members, Ken Greif, asking whether the Philadelphia Ethical Society and one of its leaders could join the case. And we were happy to accept this offer. Because Richard Kiniry lived in Philadelphia, while Hugh Taft Morales resides in Maryland, it was decided that Richard would be the one who would participate in the case on behalf of your congregation. I was very sad to hear about Richard's recent passing, and let me take a moment to commemorate his life. I knew Richard only briefly and only in connection with the lawsuit, but I got to know him enough to see that he was a warm and caring man who had a deep passion for social justice and a wry sense of humor, which he'd occasionally use to point out the absurdities of modern society. After he got involved in the case, he was quick to recognize that our legal system tends to make things much more complicated and difficult than they need to be. Something that lawyers like me, practicing law day in and day out, often lose sight of. For example, in lawsuits, there's a process called discovery, in which each side sends written requests for documents and information to the other side. When we receive some document and information requests from the attorneys from the Pennsylvania House, we drafted some responses that were rather long and full of objections and legalese to the scope of what the House was requesting. When I sent the draft responses to Richard, he remarked that while they were fine substantively, they added support to the old adage from Shakespeare's Henry VI. The first thing we do, let's kill all the lawyers. I'm still litigating another case that exemplifies Richard's cogent realization that there are some serious problems with our legal system. Because that case, in which we are challenging the state of Kentucky's funding of a religious child care agency that has proselytized the children in its care and fired one of their counselors when they learned that she was a lesbian. That case has been going on for 20 years with no end in sight. But let me get back to telling you what happened in our lawsuit against the Pennsylvania House. When Richard and your congregation joined the case, a Unitarian Universalist minister of Philadelphia area Unitarian Universalist Church, who also happens to be a humanist, joined the case as well. We asked the House to give permission to Richard and the Unitarian Universalist minister to open a House session day with a non-theistic prayer. Unsurprisingly, the House rejected this request. But this time, the House could not reject the applicants on the grounds that they were not members of a religious organization, because both your congregation and the Unitarian Universalist Church are legally recognized as religious organizations. Instead, the reason that the House gave was that the opening invocation at House sessions must appeal to God, a supernatural higher power, or the divine. And Richard and the Unitarian Universalist minister were not willing to pray to a divine higher authority. We proceeded to litigate our lawsuit, arguing that the House's refusal to permit non-theists to open House session days with secular invocations violated two fundamental constitutional principles. First, the Constitution prohibits government bodies from discriminating among people based on religion. But the House was discriminating against people who do not profess belief in a God. Second, the Constitution prohibits the government from becoming entangled with religion by prescribing the content of prayer. But the House was requiring that its opening prayers invoke a divine higher authority. But before I go any further, let me answer some questions some of you might have. Why is it permissible for a legislature to have opening prayers at all? Doesn't that violate the separation of church and state? Were Richard and the Ethical Society trying to obtain equal rights to participate in something that should be illegal in the first place? Now, my organization and I do believe that sessions of state legislatures should not be opened with prayers, and that the Constitution's First Amendment, which requires a separation between religion and government, should not be construed as allowing this practice. But in a 1983 decision called Marsh versus Chambers, the U.S. Supreme Court disagreed. The Supreme Court explained that just 3 days before approving the text of the First Amendment, Congress authorized the appointment of paid legislative chaplains to open sessions of the U.S. House and Senate with prayers. Therefore, in the view of the Supreme Court, Congress couldn't possibly have intended the First Amendment to prohibit opening legislative sessions with prayers, because otherwise the First Amendment would have outlawed what Congress had just done. Now, the presumption that the Supreme Court made in that case, that members of Congress early in our country's history must have acted consistently with the Constitution, has some big problems. For example, less than a decade after approving the First Amendment, Congress passed the Sedition Act, a law that has long been considered to have been plainly unconstitutional because it made criticizing federal officials or the United States a crime. And less than 7 months after approving the Bill of Rights, which also contains the Eighth Amendment, which prohibits cruel and unusual punishment, Congress passed a law providing that people convicted of certain theft crimes be publicly whipped. Surely, no one would argue today that it is constitutional to punish theft by publicly whipping people. At least I hope not. Even though its logic is dubious, the Supreme Court's Marsh v. Chambers decision, which upheld prayers at the openings of legislative sessions, that decision has been the law of the land for nearly 4 decades. Indeed, in 2014, another case concerning prayers at meetings of government bodies, called Town of Greece v. Galloway, reached the Supreme Court. In the Town of Greece case, which my organization sponsored and litigated, not a single Supreme Court justice took the position that it should be unconstitutional for legislative bodies to open their sessions with prayers. Instead, the Supreme Court ruled that not only state legislatures, but also local government bodies can constitutionally open their sessions with prayers, and that it is constitutional for those prayers to contain sectarian references, such as references to Jesus Christ. Again, the Supreme Court's reasoning was principally based on history. The court emphasized that since the late 18th century, opening prayers before Congress have sometimes contained sectarian references. The Town of Greece decision did have a silver lining, however, because it made clear that legislative bodies must not discriminate based on religion in selecting the people who open their sessions with prayers, and that legislative bodies must not prescribe the content of the prayers. As I mentioned before, our lawsuit against the Pennsylvania House rested on these 2 principles. We had hoped that our lawsuit would lead to a ruling that would vindicate those principles and establish a precedent that would guarantee equality and inclusion for non-theists. Richard and the other plaintiffs in the case wanted to deliver opening invitations to the Pennsylvania House to advance these goals, to demonstrate to all residents of Pennsylvania that people who don't profess belief in a God can deliver meaningful and inspiring messages on ethics and morality, and to teach Pennsylvanians who might be suspicious or distrustful of non-believers that there is no reason to fear us. Fulfilling these goals would have meant a lot to me personally as well, because while I identify myself as Jewish ethnically, I consider myself to be a non-theist as well. Let me take a few moments to step away from talking about the case again and tell you about my background and why I ended up working as a constitutional lawyer fighting to preserve church-state separation. One thing I found interesting about the individual plaintiffs in the lawsuit against the Pennsylvania House was that all 7 of them were raised in a monotheistic religious tradition and at some point in their lives became non-believers. I, on the other hand, was raised as a non-believer. I was born in Kiev, Ukraine, when it was part of the Soviet Union. At that time, the Soviet Union was governed by a totalitarian regime that used its educational system and its media to indoctrinate children into atheism, as well as the belief that communism was a utopian form of government, and that other political systems were inherently evil. Although the Soviet Union had a constitution, it was nothing more than a piece of paper that the government paid no attention to. People had no rights, and dissent was not tolerated. I did not realize any of those things when I was there as a child, because my family members were afraid that they would be punished by the government if they said anything smacking of dissent to me, and I then spoke of those things to others. I only learned the truth about what kind of political system I had been living in shortly before my 8th birthday, when my family and I were lucky enough to be able to emigrate to the United States. I learned then that some of my family members had been imprisoned and killed by the Soviet government under Joseph Stalin because they had been suspected of being dissenters. I learned that because my family was ethnically Jewish, we had been discriminated against by the Soviet government in various ways. For example, through denial of admission into desirable educational institutions. And I learned that Jews in the Soviet Union who had wanted to practice their religion could not do so openly, but had to do so in secret, because attempting to openly practice would have made them lightning rods for retaliation by the Soviet government. And while it was important to my family to maintain their identities as Jews after coming to the United States, they had no interest in actually adopting any belief in a God. If there was a God, they asked, how could he have allowed all the suffering that Jews experienced in the Soviet Union? So as I grew older in the United States, nobody ever tried to convince me, nobody close to me ever tried to convince me to believe in a deity. And it never made sense to me to believe in something that could not be empirically proven. Thus, I remained a non-theist throughout my youth and thereafter. As I grew up in the U.S., I also learned about the U.S. Constitution, that it was the country's fundamental legal document, that it guaranteed certain rights to all Americans, and that a robust court system existed to protect these rights. The differences between the American system and the Soviet system that I had left brought home to me from a young age how important it is to protect the rights enshrined in the U.S. Constitution. How dangerous it is when a government attempts to impose any sort of orthodoxy of belief upon its citizens. And how important, in particular, is the principle that the government must not discriminate based on religious belief. For the last 2 decades, as a constitutional lawyer for Americans United for Separation of Church and State, I have had the privilege to be able to fight for these principles every working day. In our lawsuit against the Pennsylvania House, we initially obtained a victory in favor of these principles. A federal district court ruled that the House's exclusion of non-theists was unconstitutional, The court explained that the House was intentionally discriminating based on religion and that the Constitution prohibits this. Unfortunately, our victory would not last. The House appealed the decision to the U.S. Court of Appeals for the Third Circuit. The appeal was heard by a panel of 3 judges, and they voted 2-1 to uphold the House's discriminatory policy. Like the Supreme Court did in its rulings concerning opening prayers. The 2 judges who ruled against us relied on history for their decision. The main basis of the ruling was that historically, prayers that have opened sessions of legislative bodies have always been theistic. The 2 judges paid no attention to our argument that history should never justify discriminatory practices. After receiving this terribly disappointing decision, we had to decide whether or not to keep fighting the case. We had 2 options for appealing. First, ask the entire U.S. Court of Appeals for the Third Circuit, which has 14 judges, to rehear the case. Or second, to ask the U.S. Supreme Court to review the case. We didn't want the case to go to the U.S. Supreme Court because we feared that if the Supreme Court did take the case, there would be a high risk that it would rule against us and issue a decision that would create a nationwide precedent harmful to equality for non-theists. When President Trump replaced the moderately conservative Justice Anthony Kennedy with a much more conservative Brett Kavanaugh in 2018, he cemented a 5-justice conservative majority on the U.S. Supreme Court that is hostile to the separation between religion and government, and that has repeatedly elevated the interests of majority religions over the rights of religious minorities. For example, in recent years, the Supreme Court has upheld the display of a 40-foot cross on government property as a war memorial. The court has upheld the Trump administration's ban on entry to the U.S. by citizens of certain predominantly Muslim countries, despite repeated statements by President Trump demonstrating that the ban was motivated by anti-Muslim animus. The court threw out a state court's ruling that a Christian baker violated the civil rights of a same-sex couple by refusing, for religious reasons, to sell them a wedding cake. And the court ruled that a closely held corporation had a right to a religious exemption from regulations requiring coverage for contraceptives to be included in health insurance plans. Because we did not want the U.S. Supreme Court to have an opportunity to issue a similarly terrible ruling in our case, we also decided not to ask the entire Third Circuit to rehear the case. That's because if the full circuit had agreed to rehear the case and had then issued a ruling in our favor, there would have been a high risk that the U.S. Supreme Court would have then granted review. The Supreme Court often grants review of a case when different federal appellate courts decide the same issue differently. And while the appeal in our case was pending, 2 other cases presenting the same issues that our case did were decided by other federal appellate courts. In one case, which our organization did not bring, the U.S. Court of Appeals for the D.C. Circuit ruled that the U.S. House did not violate the U.S. Constitution by refusing to permit an atheist to deliver a secular opening prayer at one of its session days. In another case, which our organization did bring, the U.S. Court of Appeals for the 11th Circuit held that a Florida county violated the Constitution by discriminating against theistic religious minorities when selecting people to give opening prayers to it. But the court refused to decide whether the county could constitutionally exclude non-theists, even though the plaintiffs who brought the case were non-theists whose requests to give secular invocations had been rejected. So, if we had convinced the entire Third Circuit to take the case, and if the court had ruled in our favor, and even that outcome would have been quite unlikely, because 8 of the 14 judges on the Third Circuit have been appointed by President Trump or former President George W. Bush. But if the entire Third Circuit had ruled in our favor, that would have created what's called a circuit split between the decisions of the Third Circuit and the D.C. Circuit, setting the case up for likely Supreme Court review. So to avoid the risk of a terrible Supreme Court decision that would have established a bad precedent for the whole country, we made the difficult decision to stop fighting the case and not to appeal the loss. This was a painful decision both for our clients and for myself. I'm used to fighting a case until all avenues for appeal are exhausted. For example, about a decade ago, I filed a case challenging a Wisconsin public school district's practice of holding its public high school graduations in an evangelical Christian megachurch, where the students stood underneath a giant cross as they received their diplomas, and family members watched them do so from pews filled with Bibles, hymnal books, and church promotional cards that asked them whether they, quote, would like to know how to become a Christian. Non-Christian students and their family members were presented with a choice between submitting to a religious environment that made them deeply uncomfortable and missing their own high school graduations. We initially lost this case before a federal district court. We lost it before a 3-judge panel of the U.S. Court of Appeals for the 7th Circuit. But we asked the entire 7th Circuit to hear the case, and we ultimately won by a 7-3 vote. This victory for the rights of religious minorities in the public schools was one of the most rewarding of my legal career. That victory came in 2012. But now that the Trump administration's judicial appointments have resulted in judicially conservative majorities on the U.S. Supreme Court and on most of the federal appellate courts, there are much greater risks of creating bad precedent than there were when I litigated that school case. And we have to think strategically about when to stop fighting. That brings us to the question, what do you do when you're faced with an environment where the decision makers appear to be stacked against you, and it has become harder and harder to achieve your goals? Well, you don't give up. You keep fighting, but you figure out how to fight smarter. For example, faced with an increasingly conservative federal judicial system, my organization is bringing more cases in progressive state court systems. In recent years, for instance, we succeeded in using litigation in the New Jersey state courts to block proposed state grants that would have supported religious instruction and religious discrimination at an Orthodox Jewish yeshiva and a Presbyterian seminary. We obtained a ruling from the Massachusetts Supreme Judicial Court blocking the use of public tax dollars to restore stained glass windows featuring Jesus Christ and a cross in a church. We obtained a ruling from the Colorado Supreme Court blocking a school voucher program that would have principally funded religious instruction at religious schools that discriminate based on religion in admission. And we are preparing to soon file a lawsuit in the Florida State Court against a school voucher program there that principally funds religious schools, including ones that discriminate based on religion, sexual orientation, gender identity, and disability. In federal court, we've been fighting Trump administration arguments. We've been fighting Trump administration regulations, not just through constitutional arguments, but also through more technical arguments. Generally, that the regulations are contrary to the applicable statutes. Even ideologically conservative judges who may see themselves with a great deal of leeway on how to decide issues of constitutional law that are typically unsettled are unlikely to ignore arguments that a regulation is defective because it contradicts the statute that the government claims authorizes it. For example, we recently obtained a federal court ruling blocking Trump administration regulations that would have given healthcare providers and their employees broad authority to deny healthcare services based on religious objections. These regulations would have particularly harmed LGBTQ people and women. The judge concluded that the regulations were unlawful because they contradicted the very statutes that the government claimed to be implementing. We're making similar arguments in another case, which a federal district court recently allowed to proceed, that challenges Trump administration regulations that give all for-profit and nonprofit institutions broad authority to exempt themselves on religious grounds from legal requirements that health insurance plans cover contraceptives. Likewise, in a case in which we are challenging funding of a foster care agency that requires prospective foster parents to be Christian and to profess agreement with an evangelical Christian statement of faith, which means that many Christians can't even qualify, including many Catholics. We are arguing not only that the state's funding of the agency violates the U.S. Constitution, but also that a Trump administration directive that authorized the state to continue funding this discriminatory foster care agency was procedurally defective. So the message that I want to leave you with today is that even though these may be difficult times, and it may seem like it's harder and harder to successfully battle for what you believe is ethical and right, as those who place their own interest above the greater good of society and humanity have been gaining more and more power. Do not despair. Do not give up. Instead, think about where the best opportunities are to successfully fight for what you believe is right and ethical, and what the smartest ways to fight for those things in a changed and difficult environment are. And keep fighting. I'll be available to answer questions during the post-coffee discussion period. And if you're interested in learning more about my organization, there are some pamphlets on the table back there in the front lobby. Thank you very much.